So chapter 15, priority of creditors. What are we looking at in here? So we're going to look at ways people may secure their debt by using personal property, by using real property, or guarantees, or any other forms. And also we'll look at some rights and other details related to creditors. And we'll end by looking at bankruptcy, briefly looking at how bankruptcy, either on an individual and both on an individual and business levels work. Okay, so let's start talking about those methods of securing a debt. Well, first of all, let's keep in mind that, let's say your neighbor comes to you requesting $10. Your neighbor wants to borrow $10 from you. So you give them $10 if you have it, and then they will come back to pay you. Your neighbor will come back to pay you. But you have no guarantee. You may have, you may have a contract. You do have a contract because it's verbal, but you may even have a written contract, etc. But if your neighbor doesn't come back to pay you, you have to sue your neighbor, try to recover the payment, the debt. However, in business, creditors have some methods, some tools, some possibilities to secure their to secure a debt. So instead of only relying on the promise of being paid, they may want the debtor to offer a type of property. So in the same example, your neighbor wants to borrow $10 from you. So let's say you say, okay, I'll lend you $10, but I want to keep your lawnmower just as a security. It's not mine. So your lawnmower will be kept with me, and then when you come back to pay me, I'll give you back the lawnmower. But if you never come back to pay me, then the lawnmower will be mine. I know a lawnmower is much more expensive than $10, but just to give you an example. So the first example, you had no security, just a promise. But now in the second example, you, the creditor, you have a type of security. You have a personal property, a lawnmower, in case your neighbor, your debtor, does not repay their debt. So those are types of financing transactions we'll be looking at from now on. In other words, what I'm saying is that the creditor will have a claim on the debtor's property. So you will have a claim in case the debtor does not repay you properly. And personal property, they are used a lot as security. And you're not required to know the specific names here, like pledge, for example, but you need to understand how the transaction works. So the pledge is actually a pledge transaction is actually the example I gave you about the $10 and the lawnmower. But here in the slides, I'm giving you the pawn shop jewelry example. So you have a gold ring that is worth, let's say, 10,000, and you need some money. So you go to a pawn shop to get a loan, and you offer your 10,000 gold ring as security. So in a pledge, you are using your personal property and you have the title. When I say title, I mean you have the ownership. You are the owner of your gold ring. However, possession is given to the pawn shop owner. So they will keep possession of your gold ring. The same thing I exemplified with the lawnmower. And then, if the debtor comes back to repay the loan, they will get back their gold ring. Because title was theirs always, but then they will recover possession. In case the loan is defaulted, then the pawn shop owner already has possession. They now have the title and they can sell, so they will recover their losses. So this is the first type of the first method to secure a debt. We call it pledge. So pledge is when we transfer possession, not title, but just possession, just keeping the item to the creditor, and the creditor will give us back possession of our property when we end or finish repaying our loan. Okay? The conditional sales agreement. So this is used a lot for companies, for manufacturers, and the buyer will take possession of what they're buying, like machinery, equipment, but they are not taking title yet because they are in a conditional sales agreement. Just upon the payment of the last installment, then title will be transferred to them. We discussed this last week as well for real estate transaction. I told you in chapter 14 that when developers or construction companies are financially strong, they usually offer their own financing method to the purchaser. So they transfer possession for the purchaser, but they keep the title, they keep ownership until the last payment. And this is the same here, but now I'm not talking, examples could be with real estate, but here could also be with personal property. So imagine a company that has to invest 1 million, 2 million in a specific machinery to manufacture their products. So they could use a conditional sales agreement in case the seller is financially strong and can offer them such a method of financing. Chattel mortgage. Chattel mortgage, a bit different, but still remember chattel goods. So chattel and goods, they are synonyms. So here we have a three-party transaction. Why three-party transaction? Well, we have the seller, we have the buyer, and we have the creditor. So let me give you this example for Boeing. Boeing is the seller of airplane. Air Canada is the buyer of an airplane. But then Bank of Canada, they would be the creditor. So in this case, for a chattel mortgage, Bank of Canada would pay Boeing cash, one installment, but then Air Canada would repay the loan to Bank of Canada or any other huge bank. So Boeing, the seller, they are not the creditor. The creditor will be a financial institution. Okay, that's why I'm calling this a three-party financing transaction. This is also common for cars. So if you want to finance a car, usually the car dealership, they are not the creditor. There's usually a bank. So there's, let's say, Porsche Bank, Jaguar Bank, or, well, any other, could be Scotia Bank, RBC. So they offer the financing. So offering the financing means they will pay the car dealership the full price of the car, and then the buyer of the car, the client, will be a debtor of the bank, not of the car dealership. So those are examples of chattel mortgage. Companies, they also assign their book account. They assign their receivables. So let's say you have a company that sells goods, and your clients, they pay on a 30-day term, 60-day term, 90-day term, because they are good clients, they have good credit rating, etc. But you may need money in advance. You may need some money before you get payment to buy raw material, to pay salaries, etc. So you could transfer your receivables, your bank, your book accounts. You could assign them to a bank, to a financial institution, and the financial institution, by charging you interest rate plus service fees, would advance you, would anticipate the money to you. So let's say you have sold 100,000, and this 100,000 is due in the next 60 days, but you need the money now. So you would offer this to a bank or any other financial institution, and you would negotiate to get this 100,000 minus interest rate and service fees right away to your banking account. And the security you are offering is will be the sales you made. And if you don't repay this financing, the financial institution would intercept, would get the money right from your clients. Okay? Leases, they are actually renting. We are renting a chattel. We are renting goods. So we can lease a car. We are not the owner of the car. We are just users, the lessee. So possession is transferred to us, but title is kept with the financial institution. And then by the end of the lease term, 24 months, 36 months, 60 months, whatever the length is, we return the car to the financial institution. We also have the lease to purchase. So the lease to purchase is similar to a financing, because on the top of the renting, we're also paying for the asset, for the car. So by the end we finish paying the lease to purchase, we would be the owner's title of the car would be transferred to us, but not in an operating lease. So who collects the receivable? Well, in principle, it is the debtor that collects their receivables normally. But if the debtor defaults, then the creditor has the right to collect them. What if the receivable is not collectible? Well, the financial institution would be in risk in this situation. That's why I would say financial institutions would go through a due diligence with a company, checking their invoices, checking with their clients if they actually purchased the products, etc., to assess whether the receivable is collectible or not. But it is business. There's always a risk. The transaction could be legit, could be real, but the company that purchased the product could go into bankruptcy. They could face financial issues, issues, problems. So the financial institution does bear some of the risk. That's why they charge the interest rate plus some service fees, because there's a risk in this type of transaction. All right. Now we have to look at this PPSA system, as it is commonly known. The PPSA is the Personal Property Security Act. So it's an act that is used in Canada, so federal legislation. And the idea of this act was to create this unified approach for the use of personal property as security. So this is very important in business and in financial transactions. Why? Because there's this system called PPSA. You can Google this and research a bit more if you want. And what the system allows, it allows for creditors to place a register, to place a burden, a claim on a specific asset that was used as collateral, as security. So let me give you this example. Apple wants to get $500 million loan, and they are offering their trademark, Apple trademark. So how can you register a claim over a trademark? Well, here in Canada, if this transaction were in Canada, the creditor could use this PPSA system in which, in this digital system as it is nowadays, they would place a claim over the trademark. In case Apple defaulted to repay the loan, the creditor would have a preference to seize the trademark, to get the trademark rights. Companies do this with their stock, with their shares. So this is a very sophisticated and efficient and effective system, the PPSA. Because let's say I am a financial institution, and again, Apple comes to me for this 100 million loan, and they offer their trademark as security. But before accepting this transaction, I would check the PPSA system to learn if there are any claims already in the trademark or not. And if there were another claim, I would say, hey, Apple, no, I don't want to be second in preference. I need you to offer me a different asset, different thing. With a lease or finance for cars, there's also creditors also use PPSA. So they place a claim on the car, a claim in case the loan or the lease is defaulted, they have a preference to recover. Okay, so it's again also used to secure creditors when they lend money. And how is this secured relationship created? Well, there's an agreement. That's why contract law is so important. So this agreement is called the security agreement. And then once the security agreement is executed, is signed by both parties, the agreement will be either registered or the possession of the collateral will be transferred to the creditor. This second possibility is very rare, not common. As I said, let's say Apple, they are offering their stocks, their iPhone stocks, and those are moving stocks as collateral. So they would not transfer their stocks to a creditor, but they would allow registration. So this PPSA system would show under Apple Inc. That their stock located at this warehouse, X warehouse, Y warehouse, the creditor has a claim on them. In case they default their payment, they can seize those goods. And why are creditors interested in having their claim registered? They are interested because they will have a prior claim over everyone else. So we'll see later on in bankruptcy. So when a company goes into bankruptcy, uh, the company will be owning money to employees, to provincial and federal governments, to a lot of creditors. But the secured creditor, they will have a preference in what they have secured, in the security, in the collateral they have used. So the first to register a claim in a specific asset, they will have a priority to claim um, title or ownership of that asset. So that's why they want to have their claim registered for priority in payment in case things go bad. What are the rights and remedies? So I've been telling you this. I just want to reinforce and reiterate. So the secured party, the creditor, they may take possession of the goods and then they will sell them to recover their losses. And the debtor, they have to be provided an opportunity to redeem. What is an opportunity to redeem? An opportunity to pay what is owned and recover their asset, or not to have their asset, their security seized, their collateral seized. But if the debtor does not exercise their right to redeem and the creditor does sell the collateral, in case there's a surplus on the sale, the surplus will go to the debtor. But in case there's no surplus, in case there's still a balance owned, the debtor is still owning money. So, for example, um, I have secured a $100 loan with my iPhone. My iPhone is, let's say, $500 worth. So, and I don't repay this loan. So, in this case, if my iPhone is sold for more than $100, by the creditor, there will be a surplus. And that surplus belongs to me, to the debtor, because I was only owning $100. However, if my debt was of 1,000 and my iPhone were sold to buy $500, I would still be owning the creditor $500. Okay? So, one question for you to practice. Yes, E is the wrong one. Yes, the debtor will never be arrested or detained. So creditors, they have no right. In case the debtor has no assets, no money, you saw this in chapter 3, the creditor will be in loss. There's no possibility to have the debtor arrested or detained. All other options, they are legit rights for the creditors. All right, so moving on. There's also guarantee for financial transactions. So here, this guarantee, um, we saw this briefly. I didn't emphasize this as a financial guarantee, but we briefly saw this in chapter 7. But what is a guarantee? So let's say the debtor has no assets to offer as collateral, but they know someone who is rich, and this wealthy individual can be a can be a guarantor. So a guarantee is when someone personally guarantees the transaction. The guarantor, this person is called guarantor. The guarantor will not have to pay unless the debtor defaults payment. So the guarantor will only have to pay in case the debtor defaults. Okay, that's why we call guarantee as secondary obligations. So they are secondary obligations because they only arise in case the debtor defaults. And remember I told you that agreements, verbal agreements are as valid as written ones. However, some specific types of transactions require written evidence. I told you in the past, land transactions, transactions that are longer than 1 year. And here is another example, guarantees. So guarantees, they must be evidenced in writing, okay? So that they are valid and enforceable. So that's another way to secure a debt. Rights and obligations for guarantees. So the creditor cannot weaken the position of the guarantor. So I am a guarantor for my neighbor because my neighbor got a $500 loan. My neighbor cannot get more money unless I give my consent as a guarantor, because I cannot have my position weakened as a guarantor. Okay? So if this happens, I will be released from my obligation. Okay? That's an important thing. Something else that is very important with guarantee is related to the continuing guarantee. A continuing guarantee is an exception. So if you sign a continuing guarantee as a guarantor, you are actually waiving your rights for not having your position weakened. So you have a right, as I told you before, not to have your position weakened. However, this is not the case if you if you accept a continuing guarantee. A continuing guarantee is the one that a creditor may advance more money to the debtor without the guarantor's consent. And the guarantor will still be under this secondary obligation. So this has to be, you have to be cautious about a continuing guarantee. Other forms of security, so we have the Bank Act. You don't need to memorize the act, you just need to know that this act allows growing crops, inventories, and any other goods that are in the process of manufacturing to be used as security. So could be inventory, the example I gave you about Apple's iPhones, could be the cars for a car dealership, so on and so forth. A floating charge, they are used for stocks, mostly for stocks, for inventory. Why? Because if you offer your inventory as security, you still want to sell your inventory. But how can you sell an inventory that was offered as security? So we have this concept of floating charges, meaning that you are allowed to sell your inventory. However, if you happen to default, then your inventory will be frozen at a specific date, moment, and then you will not be able to sell anymore. You could wonder, well, why would a financial institution accept a floating charge? Because they would have inventory as security, but then the debtor can sell that inventory, so they have security but don't have. Well, this exists because the inventory will be sold, but there will be other assets coming. Like in a car dealership, they are selling 10 cars today, but they are also receiving 10 new cars, and so on and so forth. So that's why it's a floating charge. The thing is, when there's a default, then uh, the current inventory is frozen. And as I'm mentioning here, it allows for ongoing business. So there are no issues with selling the cars, selling the inventory, because they will be free of any charges for the purchaser. Okay, so that's also an interesting way of secure a financial transaction. Builder's lien. So this is specific for construction, and builder's liens is only available for suppliers of goods and services related to the constructions. Sorry, related to the construction. So it's not available to any types of creditors. Only the creditors that are suppliers of either goods or services. So they will file a lien or a claim in the title of the property. And in case the owner of the property, the owner of the land, does not repay the loan, they can seize the property, they can sell the property and recover their loss. Okay, so this is specific for construction, for real estate. And there's a holdback in the lien. The holdback is for the owner of the property. So the owner of the property, let's say, is owning $100,000, and then there's a lien in their property. So instead of repaying the full $100,000, they could hold back 10%. So they would hold back $10,000 in a way to force the goods or services supplier to take out the lien from their title, to remove the lien from the title. And then once the lien is removed, then they would pay the remaining 10%. So that's also a type of security, not a financial security, but it's a transaction security for the owner of the property, because let's say they would pay all their debt and then the supplier would never take out the lien. They would have problems selling the property, etc., etc. So this is known as holdback. All right. So we also look here at negotiable instruments. We saw some of them, but here we see more details. And letters of credit. So negotiable instruments, they are examples are checks, promissory notes, also bills of exchange. So what is this? They are instruments, they are documents that are negotiable. They may be transferred from one to another. But before we talk about them, let's look at letters of credit. So a letter of credit is a letter in which a bank gives to another party in a way to commit to honor their client's debt. So this is not only used in international transactions, but mostly used in international transactions. So let's say I am purchasing goods from Japan. The supplier doesn't know me, so they want to be paid in advance. I don't know the supplier. I don't want to pay in advance. So we negotiate with a letter of credit. So I will supply a letter of credit. My bank will supply a letter of credit honoring or committing to honor this transaction. If I don't pay, the bank will pay. Obviously, for me, the bank will charge me service fees, fees in general. There will be costs. But this is a lot used in international trade. Those are letters of credit. Um, in terms of landlords, they have rights. What rights do they have? They have the rights to seize the tenant's assets and properties, but this is just for commercial tenancies. Remember, they are not available for residential tenancies. Okay, that is important. We also saw this last week. This is known as the right to distrain or to distress for landlords in case rent is due. We also have some transfers that cannot be used. So transfers, if you are owning property, sorry, before this, just give me 1 minute, please. I need to. So talking about fraudulent transfers and preferences, what are them? So whenever there's fraud in a transaction, those transactions, they may be reversed. So let's say in a fraudulent conveyance, what am I doing? I would be transfer title of a property to someone else, but in a fraudulent way, just to make the property not available to my creditors. So in case I know I will be in a financial difficulty, I may be bankrupt. Before I am bankrupt, I decide to fraudulently transfer title of my properties. But those are not real transactions. They're just transactions that that have an objective to avoid those properties to be available to creditors. So in case creditors can get evidence on those transactions, they are able to have them reversed. And fraudulent preferences, they are when a debtor pays an unsecured creditor before a preferred creditor. So this type of transaction can also be reversed, and they are known as fraudulent preferences. So the legal, the legit and legal preference was not complied with, was not followed up. Okay, so when there's clear evidence on those, the creditor, they may be able to reverse those transactions, those fraudulent conveyances and preferences. Okay, so now we go to bankruptcy. And bankruptcy, it is federal law as well in Canada, so the rules are the same everywhere in Canada. And the objective of bankruptcy and insolvency, the Bankruptcy and Insolvency Act, is to try to preserve as many of the debtor's assets as possible for the benefit of the creditors, and also to try to rehabilitate the debtor. How is this rehabilitation taking place? Well, by forgiving some of the unpaid debts. Not all, but some of the unpaid debts may be forgiven. And before we go through the details of bankruptcy, it's important to understand the difference between insolvency and bankruptcy. So, insolvency is when you are unable to pay your debts as they become due. So you had this afternoon, you had 1,000 in debt to pay, and they were due, and you did not have 1,000 available to pay. So you were insolvent. Bankruptcy is when the court declares you are bankrupt. So bankruptcy is actually the process in which the debtor assets are transferred to a trustee. So in other words, you need to be insolvent to be declared bankrupt. But it is not always that you are insolvent that you will be bankrupt. Because maybe you were insolvent this afternoon. Your debts became due. You had no money available. However, by tomorrow, you will get your paycheck and you'll be able to pay everything. So there will not be time for bankruptcy to be declared, for example. Okay? So bankruptcy requires insolvency, but insolvency is not automatically will not automatically turn out to be a bankruptcy. That is important. And there are two uh, types of bankruptcy, or two different processes. One is the involuntary one, and the other is the voluntary assignment. So the involuntary is when the creditor petitions to the court. They petition to the court and say, hey, that individual or that company, they are insolvent. We have attempted to collect our money for this amount of time unsuccessfully, so please put them into bankruptcy. This is involuntary. Why? Because it is initiated by the creditor. And if the court accepts to declare your bankruptcy, then the assets, if there are any, the assets will be transferred to the trustee in bankruptcy. Trustee in bankruptcy is this person or institution that will take care of the assets, the debtor assets, and they are under the trust of the court, of the judge. Okay, so this is how it works. The creditor petitions to the court, and then the debtor is still owning the creditor, but now the assets will be with the trustee that will try to use the assets at their best in a way to pay or to distribute them to the creditors. Can you be underage and bankrupt? Well, in principle, not. In principle, not. I actually let me research a bit more during our break, just to be certain. But in principle, I would say not. But I'll come back to you with a firm answer after our break. I will check on this. So that's the involuntary bankruptcy process. And we have the voluntary assignment. So you are insolvent and you decide to voluntarily file an assignment of your assets. So several companies are now doing this. Here in Canada, in the US as well. So companies, they are insolvent because of COVID-19. And before facing a bankruptcy process, they voluntarily come to court and say, hey, court, we are in serious financial problems, so we are here to assign our assets, and then the process will go on. So this is the voluntary one. Okay, so that's the difference, is that here the debtor takes the initiative for the bankruptcy process. So the trustee, what will the trustee in bankruptcy do? The trustee will hold the assets in trust. They will try to preserve the value, and they will also try selling the assets or exploring the assets at their best, and distribute the proceeds fairly to the creditors. And those creditors that have a security, a collateral, they are known as preferred creditors because they have a preferred claim. So that's why all those secure transactions we saw in the beginning of the chapter, they are relevant, because in a bankruptcy or voluntary assignment process, those creditors will have a preference to be paid. So their losses, their risk of loss is reduced, is diminished. Okay, so The priority will be the preferred creditors, and then unsecured creditors will be last. So I just brought here you the section 136 of the Bankruptcy and Insolvency Act. So secured creditors, as I said, will be paid first. Funeral expenses in case the bankrupt passed away, second. Costs for the administration of the bankruptcy, third. And then wages, salaries, etc. So, and then the list goes on, but you don't need to memorize this. This is just to give you an example or a clear picture of who will be paid first in case the assets are that are assets available. Um, the trustee is actually a normal individual, a regular individual, but is working under the trust of the court, and they are not paid by the government. They will be paid by the um, the assets themselves, here with the costs of administration. So the trustee is just a regular individual person that is under the trust of the court, and they have expertise and experience to manage assets in bankruptcy processes, but they are not government related. Okay, so there are some offenses. We saw the fraudulent preference, the fraudulent transactions, so they are offenses. And if those offenses take place, the bankrupt, the company's director, or the individual, they may be punished by fine and even by time in prison if they commit any of the criminal offenses in bankruptcy. So this is a very serious process. Okay, one something that happens commonly is assets are transferred for no value or for just a nominal value, again, to avoid the assets to be available in the bankruptcy process. This is a type of an offense, okay, and they are prohibited. Here are some restrictions. After discharge. So what is discharge? Being discharged means the bankruptcy process is ended. All assets were used, most debts were paid, and some of other debts were forgiven. And I told you that some debts can be forgiven, not all of them. Why? Some of them, they still survive, such as loans, maintenance payments, some damage awards. So some of those debts, they are not forgiven. Even though you are discharged from bankruptcy as an individual, you still have to pay those debts if you have them. Okay, so that's why only some debts are forgiven. Companies are not discharged from bankruptcy. So companies, once they are declared bankrupt, they can never survive. So to avoid being on bankrupt because the company will die, they usually use what is known as the Division 1 proposal, or they also make use of this Companies Creditors Arrangements Act. So what this means is that companies try to avoid going through bankruptcy because they want to still try to survive with the help of the court. So when companies are able to use this Division 1 proposal or the Companies Creditors Arrangement Act, they will have the support of the support of the court, to have more time to pay, to have the help of the trustee, um, to pay creditors, and then try to survive as a company. Okay, because corporations, they cannot be discharged from bankruptcy. Yeah, so one last question for you related to bankruptcy. All right, C, D. Okay, D is the right answer. D is false because D is saying that all creditors are treated equally. That is not correct. Showed you here that secured creditors are paid first, and then unsecured creditors, they are the last, one of the last. So D is the false one. C is saying bankruptcy law may allow a debtor to escape from having to pay his debts. This is true because bankruptcy law, one of the reasons is to, as I showed you here, is to it does allow the debtor to be forgiven for some of the debts. So eventually, if there are no assets at all, eventually all the debts may be forgiven, may be unpaid. So that's why C is a true statement. We were looking for a false statement. So D is the correct answer. So this is chapter 15 on financial transactions and bankruptcy.